final case to come before the court for argument today is Wendy Mistysyn versus Mistysyn. We're here for the argument. Each party will have 15 minutes to present its argument. The appellant may reserve up to 5 minutes for rebuttal. If you wish, as the appellant, to reserve time for rebuttal, let me know when you come to the podium and I'll keep track of time for you. The arguments are being visually and audibly recorded to be posted online, so please keep your voices up and remain behind the podium. You should not use the names of minors or children in your arguments. Just refer to it as the children, the child, or initials, whichever is most convenient for you. We have read your briefs and are ready to proceed when you are.
This podium?
Yes, sir.
Good morning. Or should I say good noon?
I guess that's where we are. Do you wish to reserve time for rebuttal?
I do, please. 5 minutes.
5 minutes, okay.
Your Honors, please the court, my name is John Haynes. I'm the attorney for appellant Mistysyn. We are here on an appeal from a decision by the lower court regarding a motion that had been filed for more child support. And the parties were divorced, as the brief show, on March 16th, 2015. After I filed my brief, the 9th District Court of Appeals, this Court of Appeals, issued an opinion that I believe is on all fours with the case that we have at bar today. In this case, the facts are fairly, they're fairly easy to understand. These parties were divorced. They had 2 children, V and M. V is 18 now, and she is a student at Ohio State, and M is a student at St. Edward's High School in Lakewood, Ohio. At the time of the divorce, it was settled, by the way, by agreement. Opposing counsel and I sat down with our clients and worked things out. And at that time, a settlement was reached whereby the parties divided almost $11 million in assets. My client at the time worked for Sherwin-Williams as a controller, and they had substantial monies in stock and bank accounts and options with Sherwin-Williams, and they each walked away with $5 million from those accounts, and the appellee walked away with a house paid for in Avon Lake, Ohio, and a house that had come to her and Alan through her family, which was a lake house in Huron, Ohio. My client agreed to pay $8,000 a month in spousal support, $2,500 a month for the support of the 2 children, and he also agreed to pay for the education of the 2 children at rather exclusive Catholic high schools on the west side of Cleveland, Magnificat for the daughter and St. Ed's for their son. He also agreed to pay for all of their expenses for health care, orthodontic care, dental care, and the appellee was responsible for the utilities at her homes, the cell phones of the children, gasoline for cars that my client eventually purchased for the children. This all occurred in March of 2015. And then last year, in 2017, my client was named the Chief Financial Officer of Sherwin-Williams, and his base salary doubled. And along with options, along with other incentives and shall we say bonuses from how the company fared, he was to make substantially more than what the original guidelines of the support agreement had been. Shortly after he was named the Chief Financial Officer, which began on January the 1st, 2017, the appellee filed a motion to modify the child support. And we had a hearing after discovery before Magistrate June Rising in this court, and she ruled that my client should pay $10,000 a month in child support. I believe that the facts show that this is really a modification of spousal support rather than child support. If one looks at the tenets and what we're required to do under 3119.04B of the Ohio Revised Code, I believe that the magistrate missed the boat on that. I think she did not take into consideration what is required of that statute. I will tell the court that there is no question that a change of circumstances had occurred pursuant to the dictates of that statute. There was more than a 10% increase, and that is not being argued. What we are arguing is essentially this, and when I filed the brief, I argued this, and that is, it's what I call a would have rather than a could have argument regarding an increase in child support. And I used that terminology, and this court, in a subsequent ruling, an opinion, followed that same line of thought. We have two children who are being supported by a father and a mother who live in what I would call a 1% status of this country in terms of assets and abilities. They live in houses that their mother owns now, that are free and clear of any mortgages. After the divorce, my client voluntarily paid for the daughter to drive back and forth to school in a car that he purchased for her. The evidence in the hearing showed that on one of the exhibits, he had paid close to $70,000 more from the time of the divorce till the time we had that hearing, more than he was obligated to pay, which included a car, it included clothing and things like that, tickets for ball games, and so forth. So I believe Mr. Mistysyn has been very, very generous in the way he has approached how these children are to continue to live in the same lifestyle that they were living when the parties were married and living in Avon Lake. All of their needs are met. All of their needs. He has agreed to pay for the college educations of these children. In fact, he has two accounts, one for each child. That when we had the hearing, had $200,000 in those accounts, in each account for their college education. And the daughter is a first-year student at Ohio State, and he's taking care of all of their expenses, not just their tuition and books and room and dining hall, but he handles everything, any expenses that they have. So the question here is, had these parties remained married, would there have been any more benefit by the mere fact that his income has increased considerably? And I believe that the answer to that is found in the conclusionary paragraph of the magistrate's decision, which the court just willy-nilly endorsed. And that is that she presumed, and if you read that paragraph in the conclusion, she said that it is presumed that had the parties remained married, the children could have had the benefit of his increased income. And that's just not the test in this case. The test is what evidence was shown to the magistrate that would indicate that had the parties remained together, had he received this substantial income and pay, the lives of these children would have changed. And there was absolutely zero proof to that effect. They were living, at the time of the hearing before the magistrate, the children were living in a very, very high standard, going to private schools, transportation provided for them, clothing, everything. And if one looks at where these people were when they got divorced, you find that they had 2 homes that were paid for. They had over $10 million in monetary assets. They were living in a nice area of the west side of Cleveland in Avon Lake. They had a country club membership. They had nice clothes, but not extravagant clothes. And if you look at the facts in this case, you'll find that Wendy and Alan Mistysyn lived rather conservatively, considering what they had. They didn't have private jets here and there. They didn't go on these extravagant vacations. They were conservative people, and they were able to save a lot of money, and they were able to pay their bills, educate their children the way they wanted to be educated. And so I think that the evidence in the case would indicate that unless Wendy could come into court and prove that the children's circumstances and their lifestyle and their standard of living would have been better by virtue of the increase in his salary. Unless she can show evidence to that effect, I don't think she can prevail. And I think that there was an abuse of discretion here on the part of the magistrate.
You're into your rebuttal time. It's up to you
Thank
if
you.
you want to continue.
Thank you. May it please the court, my name is Beth Tamarius, and I represent the appellee in this case, Wendy Lynch, formerly known as Mistysyn. By concession of the other side, Mr. Mistysyn's raise did in fact rise to the level of a 10% increase. There is certainly a new case law that has come out that is directly to the point of this case, and that was the JM versus LM. It was decided right after Mr. Hayes filed his brief in this case. And I would say that at the trial level, in this case, in front of the magistrate, who was in the best position to hear all the evidence, she determined that had the parties stayed married, they would have enjoyed a better circumstance and a better set of living. There was evidence presented that the appellant in this case purchased a new home to the tune of $865,000. He then put in a swimming pool and a patio of $250,000. He joined the country club. There was testimony that they go to special concerts that my client can't afford. There was testimony that the children asked her to take them to a concert, which she couldn't afford, and he was able to do so through the perks of his employment and through the perks of his actual income. The judge and magistrate determined that it was not plausible to believe, had the parties stayed married, the children would not have enjoyed the same benefits had they divorced. And I say with respect to the argument that that Mr. Mistysyn is paying for their health insurance and the benefits that they receive from health care, that was part of the divorce decree. That was part of the settlement. He retained the health savings account, and from those proceeds, he was supposed to pay for the party's health insurance coverage and any extras aside from that. His exhibit that he provided, which he says he paid over $70,000 for extras for the children, included tuition, all the health care expenses, braces, orthodontia work, dental work, therapy sessions. That was part and parcel of the negotiated property division. Also, when you look at the fact that he's paying for college, everyone appreciates that. That was from the 529 accounts that the parties had saved for and contributed to during the marriage. At the time of the hearing and the testimony provided at the hearing, Mr. Mistysyn admitted that he had not contributed any further funds to those accounts since the time the parties divorced. Again, the court here is challenged to see whether or not the magistrate abused her discretion in determining whether or not she erred in increasing the children's child support. And you look at this by a case-by-case basis. magistrate was presented evidence by both parties as to Mrs. Mistysyn's earnings and Mr. Mistysyn's earnings and what the two parties are currently contributing to the children. Mr. Mistysyn stated that he is not able to see the kids more than every other weekend, relatively, and maybe a dinner a week. So the children are not benefiting from living in his home. They're not benefiting from the pool. They're not benefiting from the country club that he has. They live in the nice home in Avon Lake, which is roughly half the size, and my client would not say that they're underprivileged. She just doesn't have the affordability and the actual lifestyle that she would have had the parties remained married. And the magistrate, in her decision, said, it is preposterous to believe that had the parties remained married, these children would not have been afforded the luxuries that their father has today. She didn't say they could have, she said they would have. So she did do the two-step process required under 31-1904B and then 31-1979A. And she looked at the cases and relied on Wells v. Wells of the 9th District. Obviously, the decision in JM versus LM had not come out yet, but I think looking specifically at that, she did make that determination as well because she looked at what the parties would have been afforded had the two parties remained married. And she determined that it is in the best interest of the children that their child support be increased. It's not a question of whether or not the spousal support would be increased. My client never sought for additional spousal support. She never made mention of spousal support. She went out and got a job and is working on her own. The magistrate specifically found that despite the fact that they separated their assets, she was not required to spend down her assets to support these kids in a manner consistent with what her ex-husband is now earning in his new position at his employment. So again, I think the magistrate, being in the best position to hear all the evidence, made a strong and solid finding, and her decision should be affirmed. And I will say specifically, there was a question as to the computation of his earnings. So Mr. Mistysyn obtained his employment January 1st, 2017. My client filed her motion to modify January 9th, 2017, and the court heard this case in August of 2017. There was no determination as to what his bonus would be. There was no determination as to what his actual stock options were or his compensation package in that new position. The magistrate did prospectively compute what she determined a basis would be for what his income could be. And I understand that that's not sound math per se. However, if you look at the deviation she gave or the in-kind consideration she gave downward for Mr. Mistysyn, she took into account possible error on her side and gave him consideration for that. So I can't say definitively the correct nature of the math, but I think she made some concession for that in her calculations. So again, I think that her decision should be affirmed and the decision of the lower court should be affirmed. Thank you.
I think it's important to look at the transcript of the record that was taken in this case. And one finds that Wendy Mistysyn would like to downplay the income that she actually had. She tried to tell the magistrate that she was earning $90,000 a year through the spousal support. She actually had income of over $500,000 because of the monies that she had received as a result of the divorce. She didn't want to use that. She said, I have 40 years of living to take care of me, and I need that money, and I need it to grow. But one of the very first things she did, as you'll see in the transcript, she went out and tore down a perfectly normal $350,000 house in Huron, Ohio, on the lake, and then spent $700,000 in building a brand new home. The key, I think, in this case is found in the second paragraph of the magistrate's decision, in its conclusion. In the instant case, the children continued to live with their mother in the $360,000 house that they lived in during the marriage. On cross-examination, Wendy Mistysyn said, I looked at buying a better house, a more expensive house, but the children wanted to live in Avon Lake and they were quite content where they lived. That was their choice. The magistrate went on to say, she continues to pay the taxes, insurance, utilities, and maintenance on the property. That was it. That was all her expenses she needs, plus food. The obligor father purchased a home valued at $1.25 million after his marriage. That's not true. The evidence showed that he paid $875,000 for the house, but he and his wife split equally the down payment, which was $150,000 each, leaving a $500,000 mortgage. They put in a patio and a swimming pool, and they both equally contributed to that. So actually, Wendy Mistysyn walks away with real estate that had no mortgage on it, and was considerably worth more than what his house was worth, where he lived with his second wife. Finally, and here's the key, it can be presumed that had the marriage continued, his own children would be living in the $1.25 million home instead of visiting every other weekend. That's an abuse of discretion. That is capricious, unreasonable, and constitutes an abuse of discretion. And I should add that if one reads the entire transcript, there's nothing in that transcript that would suggest how differently the children would live today with his increase in support. Wendy wants to say it's all about affordability. This is all about an increase in spousal support, because the children have everything they need. All of their needs are being met far and above what the normal kid has in living in Northeast Ohio. So I would ask the court to find not only that there is an abuse of discretion here, but I also think that when one reads the transcript of record, there is a weight of the evidence argument to be had here. There are three other items that I raised in my brief. Haven't had a chance to talk about them now, but counsel for the appellee alluded to the fact that the magistrate did play with the numbers here. My client's income went from $350,000 to $600,000 base. The amount that she attributed to him, the $2.4 million, that included his wife's salary, his second wife's salary.
And with that, your time is finished.
Thank you. And it also included things that he hadn't received yet, stock option values that she put in there. So I would ask you to look at that in the brief. And thank you for your time.
All right, thank you both for your presentation. This court will take the matter under advisement, issue its decision in due course. It will be mailed to both sides as well as posted on our website and on the Ohio Supreme Court website. The court will be